these states appear to be unable or unwilling to stop the genocide of the Palestinian people. So why ever would they want to recognize this place? It seems that recognition is simply smoke and mirrors. You want to recognize? Fine. But recognition can't be left on its own. If it is, then it will merely be symbolic. Your policies need to follow. The Palestine state, because it is a state, enjoys an inherent right of self-defense when it is subject to an armed attack. But now that the United Kingdom has recognized the state of Palestine, it only increases the obligations that it has.
Welcome to this episode of Expert Witness. I'm your host, Sondos Asem. Today, it's a pleasure to be joined by Professor Ardi Imseis. He's a leading authority on international law and Palestinian statehood. Ardi is a former UN official and the author of the United Nations and the Question of Palestine. We're speaking today during the session of the UN General Assembly, where France has joined a growing number of states in recognizing Palestine. This wave of recognition has followed earlier moves by the UK, Portugal, Australia, and Canada. But while these recognitions are significant, many argue that they come too late, as the genocide in Gaza continues, and the viability of the two-state solution remains in question. Professor Ardi Imseis, it's a pleasure to have you with us today.
Pleasure to be here.
Ardi, let me begin by hearing your take on these recognitions. Why do they matter under international law, and how would you respond to the arguments of skeptics who view this as symbolic or as too little, too late?
Thank you for the question. The first place to begin is with first principles. The state of Palestine already exists before these latest rounds of recognition by Western states, who are in effect holdouts, just joining the rest of the international community. So up until last week, there was about 149 states of a total of 193 member states of the United Nations General Assembly that recognize the state of Palestine. And I think after the General Assembly is complete, this session, there will be a total of approximately 160 states who recognize the state of Palestine. Given the context of what's happening now in occupied Palestine, namely what the International Court of Justice has decried as a plausible genocide in the Gaza Strip, many people are going to wonder, and rightly so, why recognition should even matter. These people will, rightly so, be concerned about the Western states who are now extending recognition, doing so only because they're unwilling, or indeed unable, they may feel, to do anything to stop the genocide, right, which is most pressing in time. And I fully understand that. From an international law standpoint, however, and a long-term political standpoint, these recognitions do still have value. Their value rests for me in three core principles of international law that attach to all states. First is the principle of non-intervention in the internal affairs of a state. Second is the principle of the territorial integrity and political independence of states. And third is the principle that where a state is subjected to an armed attack, a form of aggression, if you like, by another state, it has the right to use force in self-defense. Now, these three principles attach automatically to Palestine as a state. But the fact that Western states, France, Canada, Australia, the United Kingdom, are now recognizing the state of Palestine means that these states, London, Ottawa, and so on, recognize that Palestine enjoy these rights inherently. The right to self-defense when subjected to an attack, an armed attack, and the right to territorial integrity and political independence, and the right not to have their internal affairs meddled with from outside. The skeptics, of course, are going to look at that and say, okay, thanks for the principles, but how do you then assess the purported conditions that appear to be placed on the recognition, say by the United Kingdom, of the state of Palestine? The condition, for instance, that Hamas shall play no part in future government, for instance. And those skeptics would be correct. The UK position is absolutely incompatible with its obligation to respect the territorial integrity, political independence, and the principle of non-intervention in the state that it is recognizing, being the state of Palestine, by informing the state of Palestine that its recognition somehow is contingent on certain parties not governing in the state. For me, these conditions are no more than political bluster meant and directed at domestic audiences who take issue with the fact that the United Kingdom is recognizing the state of Palestine. No, we know from, as a matter of practice, once a state is recognized, it is recognized. And that recognition comes with a recognition that these principles apply to the recognized state. Now, going back to the context, the ongoing genocide. Look, if there's ever any evidence that Israel's intention, rather, to destroy the Palestinian people as a national group, as such, in their homeland, we're seeing it now. For the past 23 months, Israel has been engaged in very clearly an attempt to destroy the Palestinian people as a national group, as such, in their homeland. And so by having Israel's friends in the West recognize the state of Palestine as belonging to the Palestinian people, within which only the Palestinian people are sovereign, to the exclusion of all other people, including Israelis, is a very clear statement from these states that Israel, this far but no farther. You may not claim sovereignty over occupied Palestine, no matter what you do, including the destruction that you're wreaking on the people of Palestine. And it stops here. And of course, we know that this is an important move because these Western states are indeed providing Israel with diplomatic, political, military support. And so these recognitions are just the beginning, to my mind. They need to be seized upon by Palestinian advocates, by civil society actors, by people of conscience in the states that are now recognizing Palestine, to use as an entry point to demand further action from their governments, first and foremost to stop the genocide, but much more than that. And I'm happy to talk to you further about it.
Well, I'm interested to hear from you on the immediate legal obligations on these recognizing states towards Palestinians, towards human rights in Palestine. What does recognition mean, legally speaking, for example, with the UK and other Western states? How do they need to review their relations with Palestine and Israel accordingly?
Well, the United Kingdom and these other states who have recognized Palestine need to immediately review their relationships with Israel by virtue of the fact that they've recognized the state of Palestine. This is because three principles apply, among others, to all states, including the state of Palestine. The first principle is the principle of territorial integrity and political independence. The second principle is the principle of non-intervention in the internal affairs of the state. And third is the principle to respect the inherent right of the state that is recognized to self-defense when it is subjected to an armed attack. And because Israel is violating all three of those principles in respect of the state of Palestine, for one, it does not respect the internal affairs of the state of Palestine. It doesn't even acknowledge the existence of the state of Palestine. So obviously it doesn't respect the territorial integrity and political independence of the state of Palestine. It covets openly all of Palestine's territory, and it wants to ethnically cleanse and is actively engaged in ethnically cleansing that territory. And finally, it does not respect any Palestinian state's right to use self-defense, to use force in self-defense, to dislodge the unlawful occupation of its territory. Now, why does that matter? Well, these principles are all principles that bind third states as well. So by recognizing, meaning the United Kingdom, among others, so by recognizing the state of Palestine, the United Kingdom must do nothing to aid and assist Israel in its continued violation of these principles. And if it does, then it too is violating those principles. So let me give you a concrete example. To the extent that a third state, the United Kingdom, trades with Israel, Canada as well, where I'm from, trades with Israel, and does not require Israel to distinguish in this trade between items that it transports from the occupied Palestinian territory to the third state and items that might come from Israel proper, then the third state is violating its obligation to respect the territorial integrity and political independence of the state of Palestine, to respect the principle of non-intervention, and so on. And so these legal principles will shape immediately the United Kingdom's position, and will require a review of the United Kingdom's relationship with Israel. It touches on everything from Israel's claim to sovereignty in occupied East Jerusalem to Israel's claim to the whole of the occupied Palestinian territory. A very important case that your listeners should be aware of, and which binds the United Kingdom, is the 19 July advisory opinion of the International Court of Justice, 19 July 2024, where the ICJ determined that Israel's presence in the occupied Palestinian territory is in and of itself an internationally wrongful act, is unlawful. It determined that Israel is obligated to withdraw from the occupied Palestinian territory and to do so as rapidly as possible. And the international community has determined that in order for Israel to do that, the deadline was set of 18 September 2025. And of course, Israel did not meet the deadline to leave the territory by that date. And so in its ruling, the court ruled that all states, and that includes the United Kingdom, are under an obligation to do nothing to aid or assist Israel in its continued illegal presence in the occupied Palestinian territory. And this covers everything from the diplomatic support that the United Kingdom is giving to Israel, the military support that it's giving to Israel, the intelligence support, and so on, trade, economic, cultural support, and so on. So the United Kingdom, under that ruling, has an obligation to cease aiding or assisting Israel in its continued unlawful presence in the territory, which of course is now giving rise to a plausible genocide of the Palestinian people. But now that the United Kingdom has recognized the state of Palestine, it only increases the obligations that it has. It's taken those obligations now on its own, like by consent, by recognizing the state of Palestine. And therefore, there will be and ought to be a great deal of pressure placed on London to alter its bilateral treaties and bilateral engagement with Israel.
Ardi, could you address in more detail the argument of skeptics, for example, from the Palestinian community or human rights advocates in general, who dismiss the importance of recognizing Palestinian statehood and the latest announcements by several states. As a Palestinian yourself, I'm sure you've heard and you're familiar with this sort of skepticism and even cynicism. How would you react to that, and what's your take on that?
I don't blame people for being skeptical. When it comes to Western support for Palestine, it's virtually been non-existent over many decades. And so that begs the obvious question, why recognition now? For the skeptics, and I must admit, part of me shares this view, these states appear to be unable or unwilling to stop the genocide of the Palestinian people. So why ever would they want to recognize this place? It seems that recognition is simply smoke and mirrors to a lot of folks looking in on it. Merely symbolic. It may very well end up being symbolic. And if it is, then these skeptics would have been right. They would have been proved right. But because of these legal principles that I discussed that bind the United Kingdom and other states who are now recognizing the state of Palestine, provide argument, provide avenues for argument, provide entry points for further pressure to be brought to bear, doors have been opened to put greater amount of pressure on these states to alter their policies in respect of Israel. You want to recognize? Fine. But recognition can't be left on its own. If it is, then it will merely be symbolic. Your policies need to follow, first and foremost, you must cease aiding or assisting Israel in the violation of the state of Palestine's territorial integrity, political independence, principle of non-intervention in their internal affairs. You must cease all aid or assistance to Israel in its continued presence, unlawful presence in the occupied Palestinian territory. And so recognition must be followed by policy changes on the part of the Western states now recognizing the state of Palestine. If those policy changes don't come, then recognition would have all been for naught.
Does the recognition place additional duties with regard to states' relationships with the ICC or ICJ, for example?
Not duties as much, but it will now require a change in the position of the United Kingdom, Canada, and others who have argued against the state of Palestine from using the the International Criminal Court, for instance, to seek redress for violations of international criminal law by Israel on the basis that the court can't properly seize jurisdiction over the matter because the state of Palestine isn't a state. Now that these states recognize the state of Palestine, that argument is withdrawn from them. They won't be making it. And so now pressure needs to be brought to bear on them, on these Western states now recognizing to not only not make that argument, but to support the state of Palestine in seeking redress at the ICC.
I'd like to go back to the idea of statehood. You're an expert on this, in addition to other international law aspects. But one of the key frameworks that have been cited or discussed recently with regards to Palestinian statehood is the Montevideo Convention of 1933 and the conditions under the convention of what constitutes a state, the four conditions being a permanent population, a defined territory, an independent government, and the ability to enter into diplomatic relations with other states. What do you make of the convention in terms of its authority right now under international law to actually determine what a state is? And can you discuss these criteria with respect to Palestine as a state?
The Montevideo criteria for statehood are a codification of customary international law binding on all states in the world today. As a matter of practice, state practice, these criteria have been given for decades a very liberal, flexible, and permissive interpretation. We see this in United Nations admissions practice from 1955 to the very present. That admissions practice requires that only states may be members of the United Nations, and therefore, in that practice, these principles have been applied very liberally and permissively. As regards the Montevideo Convention criteria's application to the state of Palestine, there is no question in my mind that the state of Palestine fulfills these criteria. And that's not just my view, but that is the view of the overwhelming majority of states on planet Earth. Otherwise, there would not be a near unanimous opinion of this present Security Council, minus the United States, on Palestine's application for membership. But the point is that Palestine does have a sufficient number of people in terms of its population. I think it's about 5.5 million Palestinians living within the occupied Palestinian territory. So it has a permanent population. It has a territory that is recognized by the international community as forming the self-determination unit of the Palestinian people, being the occupied Palestinian territory. It has a government. Now, of course, that government's ability to act is being impeded by an unlawful, aggressive, occupying power who is physically present in occupied Palestine unlawfully, as determined by the International Court of Justice. But that doesn't mean, applying the Montevideo criteria of government, that Palestine's government does not satisfy that to a sufficient degree. It does. And finally, the state of Palestine engages in foreign relations and has done through the Palestine Liberation Organization since at least the mid-1970s. Today, it's recognized by about 160 states of approximately 193 member states of the United Nations. So It fulfills the Montevideo criteria to a sufficient degree to allow it to be a state and to be regarded as a state. And then there's just the simple practice, going beyond foreign relations capacity. States treat it like a state, overwhelmingly so. And the Western states who are now recognizing Palestine are latecomers to the party. The vast majority of the people on planet Earth and the states within which they live already recognize the state of Palestine. And so it is a juridical entity, and that statehood matters. Um, it has produced all manner of legal support to the state of Palestine, political support. So, for instance, the statehood of Palestine has allowed it to accede to the Rome Statute of the International Criminal Court. And but for that accession to that treaty, we would not now have arrest warrants out for Benjamin Netanyahu and his former defense minister, Yoav Gallant, or the prospect of other warrants for arrest of Israeli leaders. All of that is contingent on the statehood of Palestine being utilized, as the state of Palestine has done, at the International Criminal Court. Does the state of Palestine's existence juridically translate on the ground to freedom for the Palestinian people? Absolutely not. And this is because of Israel's illegal presence in the territory, its ravages on the Palestinian population, up to and including this genocide that is now happening. So there is a disconnect, I readily admit, between the facts on the ground and the juridical entity of the state of Palestine and its existence. But it is a marked feature of international law and practice. This fact, they don't cancel one another out. The obligation, of course, is on the international community to end Israel's presence, unlawful presence in the occupied Palestinian territory, to allow the Palestinian people to experience their freedom in full.
I know you've touched on this before, but what do you make of the condition by many states that are recognizing Palestine at the moment that a Palestinian state should be demilitarized? Doesn't international law recognize the right of a state to self-defense, including maintaining armed forces?
Yes, any suggestion that the state of Palestine is demilitarized, to my mind, is obscene. And this is because the Palestinian people have historically suffered ravages, untold ravages against them by the Israeli occupying power, and even before the occupation. The Palestinian people are sovereign in their state. The Palestine state, because it is a state, enjoys an inherent right of self-defense when it is subjected to an armed attack. And the International Court of Justice has already determined on 19 July 2024 that Israel's ongoing use of force, namely its occupation of the occupied Palestinian territory, which is the territorial unit of the state of Palestine, is in and of itself an unlawful use of force. It is unlawful. It is an aggression. And as such, the Palestinian state has the inherent right to use force in self-defense to dislodge the occupation from its territory. Now, to the extent that Western states like the United Kingdom appear to be imposing a condition on their recognition of the state of Palestine, that state be demilitarized, this condition has no legal validity whatsoever under international law. Any suggestion by a state like the United Kingdom, who recognizes the state of Palestine, that the state cannot or ought not enjoy its right of self-defense, or cannot or ought not have the means, the independent means to defend itself, is a violation of the United Kingdom's obligation to respect the principle of non-intervention in the internal affairs of the state of Palestine, and to respect their right as a state includes their right to use force in self-defense when subjected to an illegal use of force, which they have been.
But why do you think Palestinians themselves at the United Nations seem to be condoning or accepting these conditions? We've seen Palestinian leaders also signing up to these conditions, and of course, by extension, Arab leaders as well.
But to the extent that there are suggestions that the leadership of Palestine has said that it would be a demilitarized state, that would be unfortunate. But I don't read the New York Declaration which was passed by the General Assembly just a few days ago, as saying that. I read the New York Declaration as saying that the state of Palestine has no intention to be a militarized state, an intention now that might change later on. I also read that intention as being qualified. Again, going back to the New York Declaration, it says that Palestine has no intention to be a militarized state and is ready to work on security arrangements beneficial to all parties in full respect of its sovereignty and as long as it benefits from international protection. So if these security arrangements do not end up being respectful of Palestine's sovereignty as determined by Palestine, because it and its people are solely sovereign in the state of Palestine, and as long as the state of Palestine determines that the benefits of such international protection are not flowing to it, then no one can hold it to its earlier intention, such as it is, that it should not be militarized. No, states under international law are sovereign. And on the basis of that law, they may do any act at all not prohibited them by international law. And there is nothing under international law, including these purported intentions not to militarize, that requires the future state of Palestine, or the state of Palestine as it exists today, not to be militarized. In the context of what the International Court of Justice has declared as a plausible genocide, in the most existential moment and threat to the existence of the Palestinian people today, to even speak or to suggest that somehow the state of Palestine should not be able to defend itself is, to my mind, a non-starter.
Ardi, let me now turn to your book, The UN and the Question of Palestine, where you present the argument that Palestine's condition now under international law is one of what you call international legal subalternity. Can you unpack this for our audience and explain what it means in the current context, given all the recent recognitions of the state of Palestine and the doubts on the importance of these recognitions?
Yeah, so in my book on the United Nations and the Question of Palestine, published in 2023, I argue the existence of a condition on the international legal plane that I call international legal subalternity. The essence of this condition is that for subaltern or weaker groups on the international plane, the United Nations holds out the prospect of justice and freedom through international law and international mechanisms. And when these weaker groups go for it and make action and take decisions on the basis of this promise, the goalposts always shift. There is a withholding of the true promise of international law for these groups. To my mind, the question of Palestine and the Palestinian case before the United Nations from 1947 all the way up to the present is an embodiment of this condition. I cover the 1947 partition of Palestine, the illegality of that partition, and what it produced in violating the Palestinian people's right to self-determination. They were then the majority of the population of Palestine, by purporting to partition the country in two and imposing on the Palestinian people and on the international community as a whole the two-state framework. I move on to the fallout of the 1947-48 Nakba, and how the United Nations managed the Palestine refugees, and the legal and institutional framework that they created to deal with that problem, and the absurdities that emerged as a result, the different framework through UNRWA, through the UNCCP, and through UNHCR, and so on. And then I, in another chapter, deal with the 1967 occupation and the manner in which the United Nations has mismanaged that occupation. That chapter served as one of the bases for the 2024 advisory opinion of the court. And finally, I deal with the attempt by the state of Palestine to gain full membership in the United Nations organization, beginning in 2011, when it brought an application for membership to the Security Council, and had that application adjourned under threat then of the United States veto against it. On April 18, 2024, the Security Council put it to a vote, and the US actually vetoed the state of Palestine's application for full membership in the organization. And so I see in Palestine's experience at the United Nations an embodiment of this international legal subaltern condition, where law is continually held out as a promise to the subaltern Palestinians. And whenever the Palestinians move toward it or take decisions on the basis of it, the goalposts always seem to shift. Does that mean that law doesn't matter? No. In fact, the position that I take in the book and in my own practice as an international lawyer is that law does matter, notwithstanding the iniquitous ways in which it may be put to use. And this is because there are enough states in the world that adhere to the liberal international legal order enough to help bring change over time. It isn't a quick change, but it is a change that requires that law be used counter-hegemonically against hegemonic power, against the powers that be. So one good example of that, for instance, is the use by South Africa of the International Court of Justice and the case that it's brought against Israel under the Genocide Convention. South Africa represents, in effect, not only itself, but the whole of the global South in putting the Genocide Convention and the promise of never again shall genocide be tolerated, putting that to the Western states, putting it to the principal judicial organ of the UN, putting it to Israel, the proverbial phoenix arising from the ashes of the Holocaust under the promise of never again, or so we were told. Now, within living memory, Israel is plausibly committing genocide against the Palestinian people. And so the use of international law by South Africa has proved to be an example of using law counter-hegemonically to bring change. Another example of this, another example of this is Palestine's continued use of the International Court of Justice, continued use of the International Criminal Court, Palestine seeking its recognition from the international community, and so on. With recognition comes legal obligation on the part of states that recognize, and those provide entry points for political action and political change. Will that change come quickly? Likely not, but we live in a better world with the prospect of change than without. The state of Palestine's origins go back to 1919 and the League of Nations Covenant. Article 22 of that covenant provisionally recognized the independence of the peoples of Palestine. And at that time, the vast majority of the population of the country were Palestinian Arabs, somewhere on the order of about 97% of the population, Palestinian Muslims and Christians, had been there from time immemorial. Of course, with the onset of the British Mandate in 1922 and the incorporation into the British Mandate by Great Britain of the so-called Balfour Declaration, which promised on behalf of Her Majesty's government, promised the Zionists the establishment of a Jewish homeland in Palestine, that took a turn. So for 20 years of the mandate, the British used their position effectively as a colonial power in occupied Palestine to help establish a state within a state, being the Jewish state, right? The Jewish homeland for the Zionists, who settled that land, established their own economy, established their own currency, established their own school system, established a state within a state. And throughout this period, the sacred trust of civilization, which had been bestowed by the League of Nations on Great Britain to see to it that the peoples of Palestine, whose provisional independence had been recognized as far back as 1919, were able to exercise self-determination, was being violated by Great Britain. Enter the United Nations in 1947, when the British handed over the question of Palestine to the newly formed United Nations General Assembly in 1947. The population of Palestine at the time had then become two-thirds Palestinian Arab to one-third Jewish Zionist, all of them, or most of them, the vast majority of them, new settlers to the country. And then the United Nations General Assembly, on the recommendation of the majority of something called the United Nations Special Committee for Palestine, UNSCOP, chose to recommend partition of Palestine in Resolution 181 of 29 November 1947. The General Assembly at the time, it should be recalled, was dominated by the Western countries. I think there was only maybe about 51 states, the vast majority of whom were Western. And my review of the United Nations record, recounted in my book on the UN and the question of Palestine, reveals that the then Western-dominated General Assembly sought to resolve their Jewish question, their words, not mine, at the expense of the Palestinians by establishing a Jewish state. They said that, yes, the Jewish national home had been established as promised by the British, but in the face of argumentation that this national home did not necessarily mean a state, the United Nations General Assembly said, no, it doesn't necessarily not mean a state. And so they proposed to partition Palestine, to create a Jewish state. The terms of partition were patently unreasonable, patently illegal for the following reasons. First, the population ratio of Palestine, as I said, was two-thirds Arab, Palestinian Arab, to one-third Zionist Jewish. And yet, under the terms of the partition plan, the General Assembly allotted some 56% of the territory of Mandate Palestine to the purported Jewish state, leaving 43% or thereabouts for the purported Arab state to be carved out. At the same time, the most fertile land was given to the Jewish state, and so on. And what's even worse was the population ratio. Now, under the terms of Resolution 181, the partition plan, both the Arab state and the Jewish state were meant to be democratic states, and protective of the rule of law and equality before the law of their respective populations. But how could this be if, according to the UN record, the population of the Jewish state was to be 509,000 Arabs to 499,000 Jews? I mean, this meant that from the off, the partition plan adopted by the then Western-dominated UN General Assembly was saying, on the one hand, that the Jewish state should be democratic, and on the other hand, voting it into existence with a minority population governing, right? So from the beginning, the partition plan violated basic principles of self-determination of peoples, because if those principles, the self-determination of peoples, were to ring true, the majority population of the country, whose consent would have been required to dictate its future government, made it clear that they did not want the country partitioned. And notwithstanding that fact, the General Assembly purported to partition Palestine. 3 days after the partition resolution, civil war broke out in Palestine, and that lasted for 18 months or thereabouts. And during the course of which, in this, what is known as the 1948 war, some 80% of the Palestinian Arab population earmarked for the Jewish state was ethnically cleansed, their property usurped, they were denationalized by the newly formed state of Israel, wholesale, all of it in violation of prevailing international law. No state can denationalize populations on change of sovereignty, and this is a war crime. All of these things, the usurpation of Palestine refugee property, their ethnic cleansing, the denationalization of the Palestinian refugees, and so on, are continuing continuing internationally wrongful acts for which Israel is responsible. Now, the UN didn't legislate through Resolution 181, the Nakba, but the United Nations General Assembly and the United Nations Special Committee on Palestine knew and had been warned of the prospect of violence breaking out in Palestine in the event a partition resolution was passed, and yet the majority chose to pass it notwithstanding. This comes with a great and heavy moral responsibility for the United Nations, and it is for these reasons that to this day, the United Nations admits that it has, and I quote, a permanent responsibility for the question of Palestine until it is resolved in all of its aspects in accordance with international law. That is actually a term of art used in General Assembly resolutions, as well as by the International Court of Justice in the Wall Advisory Opinion, to refer to the UN's special responsibility, its permanent responsibility. The next big moment is the creation by the United Nations of the special regime for Palestine refugees, because the same General Assembly that purported to partition Palestine unlawfully had to look at the consequences of their partition, being the creation of the Palestine refugee problem and the ethnic cleansing of Palestine. It wasn't too long after the Nakba that the General Assembly created UNRWA and vested within UNRWA a mandate to provide for humanitarian aid and support to the Palestine refugee population until their situation was resolved in accordance with international law, by which it meant very clearly, under international refugee law, the right to return, the right to be restituted to their property, the right to be renationalized, and the right to receive compensation, both for damages lost as a result of the war, but also for lost opportunity over time. And of course, as we know, the Palestine refugees remain in forced exile 4 generations onward to this day. Well, another example of Palestine's legal subalternity was when it attempted to gain full membership in the UN in September 2011. Under the UN Charter, all states are welcome to become members so long as they A, are states, B, accept their obligations under the UN Charter, C, are able and willing to carry them out, in the opinion of the organization. And so Palestine's attempt to gain full membership in 2011 failed because when the Security Council examined the application, it examined it under a threat of US veto. So they discussed the application, and Palestine had a majority of the members able and willing to accept it, and continues to, but it was under the specter of a US veto of their application in 2011 that forced the application to be set aside and adjourned. In April 2024, the state of Palestine brought their application back on, and it was put to a vote. And that vote passed by an overwhelming majority, but it was vetoed by the United States. To my mind, and therefore did not succeed. To my mind, the fact that the United States was able to abuse its legal authority through the use of its veto power to block the state of Palestine's full membership in the organization is a perfect example of what I call the international rule by law. The veto power that is vested in the United States is law. It has that power under the UN Charter, which is an international treaty. And the abuse of that provision of law by the United States has been used to block what otherwise is a perfect application for membership of the state of Palestine in the United Nations. This is a perfect example of what it is I call international legal subalternity. Does that mean that the state of Palestine will cease its attempts to gain membership in the preeminent international organization? Not at all. They've made it clear that they will continue to do. And more states that are now recognizing Palestine also will support Palestine in that effort. So this is all to say that although you might have a one step back in terms of law being used against you, law can be used creatively, counter-hegemonically, to push, and we're seeing that being used by Palestine. And it's only a matter of time before the state of Palestine's membership in the United Nations organization is approved.
Professor Ardi Imseis, it's been a pleasure chatting with you today. I appreciate your time.
Thank you.